So we need to talk about a recent 9-0 unanimous decision issued by the Supreme Court involving the Fourth Amendment's protections and when excessive force by law enforcement impacts those rights. The Fifth Circuit has now issued a new ruling potentially defying that decision by the Supreme Court, and this could be heading back to the Supreme Court already. So let's break down what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube has not unsubscribed you. And then also, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're always expanding upon their benefits, and one of the new benefits that they added is that they're guaranteeing 4 attorneys for your specific case if you're in a self-defense situation. So I highly recommend that you check them out. You can use my codes down below, ARMEDSCHOLAR, to get $50 off of an individual plan or $25 off of a family plan, and I highly recommend that you sign up this year to lock in your price. Now, as I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 decision that was issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force impact those rights. This unanimous decision came in a case called Barnes versus Felix, and this case may already be heading back to the Supreme Court for re-review just 6 months really after the court issued that ruling. That is because the Fifth Circuit has issued a new ruling in light of what the Supreme Court said in that 9-0 decision. The Fifth Circuit has once again ruled that officers' actions are protected even under the totality of the circumstances approach, and the en banc panel in this case just denied review of this issue. The Fifth Circuit has engaged in some very interesting reviews of this case after the Supreme Court ruling and after the Supreme Court remanded this case, which now ultimately teased this case to once again go to the Supreme Court really soon after they just issued that new ruling. Now, the facts surrounding this case are as follows. Essentially, a law enforcement officer, Roberto Felix Jr., pulled over an individual, Ashton Barnes, for suspected toll violations. I believe there were some cameras in the Houston area that picked up some toll violations, and there are some reports that potentially also this vehicle was a rental car. Officer Felix ordered Barnes to exit the vehicle, and Barnes opened the door and acted like he was going to exit, but then he tried to drive away. He attempted to flee, which was a horrible decision. But, this was getting even worse because of how the police officer reacted, and he reacted in a split second, and the officer decided to jump onto the ledge of the car as it was driving away. He then pulled his firearm as the car was driving away because he was on kind of the ledge of the car, and he fired 2 shots at Ashton Barnes, hit him both times, and then Barnes was fatally hit, pulled the car over, but unfortunately he passed away because of this incident. In response to this incident, Barnes' mother sued Officer Felix on behalf of her son, alleging that the officer violated Barnes' Fourth Amendment rights against excessive force. Now, on review, the district court granted a summary judgment in favor of the police officer, applying the Fifth Circuit's moment of threat rule. The Court of Appeals affirmed, explaining essentially that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. And under the rule, events leading up to the shooting are not relevant and cannot be considered. Now, this case eventually made its way all the way to the United States Supreme Court this term, and on review, the Supreme Court issued a unanimous ruling, and they held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. They stated that the inquiry into reasonableness of the police officer and that force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis and instead applied a totality of the circumstances approach. They stated, most notably here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter the most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. So the main thrust of that ruling by the Supreme Court was rejecting the more limited scope of analysis applied by the moment of threat rule in the Fifth Circuit, and instead the Supreme Court ordered that the lower courts needed to relook at this case and use the totality of the circumstances approach and look at incidents and circumstances before and during the incident to determine whether or not the Fourth Amendment rights of Mr. Barnes were violated. Now, after the Supreme Court issued that ruling, the case was then sent back down to the Fifth Circuit for re-review to apply the correct totality of the circumstances approach. Now, interestingly, the panel in the Fifth Circuit did not hold oral arguments or ask for additional briefs in light of what the Supreme Court said in their new ruling. Instead, they just re-ruled on the case on their own without additional briefs or with new oral arguments. In the new ruling, the panel held that even under the totality of the circumstances approach, the officer's actions were warranted. The panel reasoned that any vehicle flight creates a deadly threat and that Felix reasonably was using lethal force because he was responding to that deadly threat of the individual here, Ashton Barnes, fleeing from the stop. Now, because of that very new and quick decision by the Fifth Circuit without additional briefs or oral arguments, Barnes' attorneys then petitioned for the Fifth Circuit en banc panel review of that ruling, and they wanted the Fifth Circuit to reverse that, and they wanted at the very least for additional briefs and oral arguments to be submitted. The petition argued that the new ruling by the panel contradicts what the Supreme Court just said in their ruling, and even that Judge Higginbottom before, that ruling by the Supreme Court said that if they had to use the totality of the circumstances approach in that analysis, there was no way that they can rule in favor of the officer. But then after the ruling by the Supreme Court and the remand to them and the forcing of having to use the totality of the circumstances approach, suddenly they still rule in favor of the police officer. The petition urges rehearing because the new ruling effectively creates this per se rule that officers may shoot any fleeing driver even when only a minor stop is involved. This case and this petition argues that this conflicts with Supreme Court cases and other long-standing Fifth Circuit precedent that fleeing in a vehicle does not automatically justify deadly force by a police officer. However, the Fifth Circuit en banc panel has already denied review to this case, and recently they submitted a notice of denial saying that they are not going to take this en banc. As a result of the Fifth Circuit three-judge panel issuing that new ruling and the denial by the Fifth Circuit en banc panel, a mandate has now issued. It issued on the 21st, and that's closing the case at the Fifth Circuit level at the very least. But Barnes' family now has the option to go to the Supreme Court, which they likely will do. They're going to seek Supreme Court review. I believe they have 90 days after that mandate to now seek Supreme Court review, which would push them into kind of early February. And this is a case that could already be heading back to the Supreme Court for a re-review just a few months really after the Supreme Court issued that 9-0 unanimous ruling in their favor. So this is something that we will be watching closely to see how this plays out. It's surprising that the Fifth Circuit panel decided to issue a new ruling on that case without requesting additional briefs or oral arguments in light of what the Supreme Court just said in that new 9-0 ruling. And now even more interesting is the fact that the en banc panel denied review to this case and really didn't also ask for any additional briefs or arguments or even push this back down to the three-judge panel or maybe even the district court for further briefs and analysis in light of what the Supreme Court said. This now teased this case to go back to Supreme Court just 6 months after the court issued their new ruling and remanded this case for a new ruling and new analysis in light of what they said. The petitioners argue that the Fifth Circuit has failed to properly apply the new Supreme Court ruling, and they may go to the Supreme Court once again to ask for the Supreme Court to step in. So that's what's happening currently in this critical case, which was recently ruled on by the Supreme Court, and this may already be heading back to the court for a re-review. So as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the two videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.